The federal judicial system is established in the Constitution. The Constitution provides that the judicial power of the United States shall be vested in one Supreme Court and such inferior courts as Congress may from time to time ordain and establish. We actually end up with two types of federal courts: the constitutional courts, which are specifically authorized in Article 3. These include the Supreme Court, the Courts of Appeals, and the various district courts. Now, this is a diagram taken from your textbook of the federal district court system. You will notice that in addition to those courts we've mentioned, there are such things as federal regulatory agencies, territorial courts, tax court, etc. We'll explain how those fit in a minute. There are three, as we said, levels of constitutional courts: the Supreme Court, the Court of Appeals, and the district courts. The Supreme Court consists of 9 judges, and it is the Congress that establishes the number of judges. That is not established in the Constitution. They are appointed by the President, confirmed by the Senate. Judges tend to be picked on the basis of their political philosophy, their intellectual ability, and to some extent their partisan affiliation, and it requires Senate confirmation. The Supreme Court has both original and appellate jurisdiction. Its original jurisdiction involves, as lined out in Article 3 of the Constitution, cases involving foreign diplomats, cases involving a state and the United States as a party, another state, citizens of another state, or foreign nations. Now, having said that, the Supreme Court has not accepted a case on original jurisdiction except cases involving states suing states for almost 100 years. It primarily serves as an appellate court, and there's 2 ways to get into the Supreme Court: either through the Courts of Appeals, the Court of Appeals for the Federal Circuit, or the legislative courts, which we'll discuss in a moment. Or you can appeal from the state, the highest court in the state, which can hear the case, not necessarily the Supreme Court, but there has to be a significant federal question and a constitutional issue involved. There are 11 courts of appeals in the states, 1 for the District of Columbia, and then a very specialized court called the Court of Appeals for the Federal Circuit, which hears very specialized kinds of cases such as patents, copyrights, claims against the United States, and international trade. In each judicial circuit, and it's called a circuit, the judges are appointed for life, confirmed by the Senate. The various circuits do not have the same number of judges. The number can range from 6 to 28 as authorized by Congress. They are generally heard in panels of 3, but the court can hear the cases en bloc, which means as an entity. They have appellate jurisdiction only. Cases cannot originate in the Court of Appeals. They have appellate jurisdiction on cases from federal district courts, from regulatory commissions, or legislative courts which have district status. Now, all Courts of Appeals judges are appointed by the President, confirmed by the Senate. Judicial courtesy plays only a minor role, and the recommendations from the legal profession carry tremendous weight. There is a specialized court called the Court of Appeals for the Federal Circuit. It was created to hear appeals from things like the Court of Veterans' Appeals, the Courts of Federal Claims, the Court of International Trade, the Court of International Trade, the International Trade Commission, the Patent and Trademark Office, and the Merit Systems Protection Board. I don't expect you to remember that. It's just a highly specialized court which takes the burden off of the regular courts of appeals because they specialize in these very specific kinds of cases. Then the nation is divided into 91 judicial districts. No district is larger than a state. Some states have several districts. For example, Texas and California have 4 each. Each district can have between 2 and 28 judges, depending on how many court cases are filed in the state. The judges are appointed by the President for life and confirmed by the Senate. Now, there's a provision in the textbook that talks very specifically about senatorial courtesy, and I'd like you to read that. They serve terms of good behavior, which is traditionally considered a life term. The role of senatorial courtesy is fairly complicated. That the senior citizen of the president's party, or the senior citizen if the state does not have a party from the president's political party, can recommend district judges. And basically the Senate will not confirm anyone that has not been recommended or at least approved by that senator. District courts have original jurisdiction only for crimes, federal crimes, civil suits under federal law, cases involving citizens of different states where the amount in controversy is at least $50,000, bankruptcy proceedings, admiralty and maritime jurisdiction, and review of the actions and regulations of some federal agencies. Now here's a breakout. It's in your book of the geographic boundaries. Now we talk about the legislative courts. These are specialized courts created by Congress with very specialized jurisdictions. And some examples of that would be the Court of Federal Claims, the Tax Court, the Court of International Trade, the Court of Military Appeals, which applies military law, the UMCJ, the Uniform Code of Military Justice, not civil law, or not general criminal law either. The Court of Veterans Appeals, which hears cases from from the military, particularly things like the Veterans Administration, and the territorial courts for the areas which are territories of the United States. Now there's an office called the Solicitor General. He's appointed by the President and confirmed by the Senate, considered the third-ranking officer in the Justice Department, and his job is to handle all appellate court jurisdiction or oversee all appellate court jurisdiction in the federal courts. He decides which cases to appeal, reviews and modifies the government's briefs, argues the case before the Supreme Court, and can present amicus curiae, that is to say, cases where the federal government has an interest but is not directly involved. Now, in order for the Supreme Court to take a case, it has to issue a writ of certiorari to a lower court to hand the case up. A writ of certiorari is an order by a higher court of appeals to a lower court to hand up the case for review. Generally, a state court has decided a federal question. Two federal courts are in substantial disagreement. A federal court of appeals has decided a question not previously reviewed by the Supreme Court. Those are all good game for writ of certiorari. Again, continuing, if a federal court of appeals has held a state law unconstitutional, the state can appeal, and generally the Supreme Court will take it. If a state court has held a federal law invalid or upholds a state law which has been challenged as violating federal laws, they may issue certiorari, or if a federal court holds an act of Congress unconstitutional. Now, once it gets to the Supreme Court, the court, after it has opinions, after it has heard the hearing and read the briefs on the question, renders any one of several different kinds of decisions. The first is a per curiam, where they simply decide, but they don't tell you why they decided. A majority opinion is the opinion of 5 or more justices. Now, plurality opinions are the hardest thing to understand. There may be 5 judges who agree with the decision but not the reason, and in which case they will write either concurring opinions in which they agree with the decision that has been reached but have different reasons for having done it, or they may disagree with the decision and dissent. Now, what are the limits on court decisions? Obviously, the Constitution, to some extent the laws passed by Congress. Precedent is a very important part. Politics, and then the practicalities of actually enforcing something if you make the decision. Finally, some key things to remember. The judiciary really is a very important part of policy making. It has considerable discretion in the making of decisions, but the judiciary is a political as well as a legal institution. And when we get to our discussion again of Citizens United, we'll talk about how the Supreme Court made what I think was a boo-boo when it decided in Citizens United. Ultimately, I think the decision will be overturned, but whether it will be overturned by the court or by constitutional amendment is a good question.